We're live.
All right, good morning. We are back in Senate Judiciary. It's February 12th. We're going to spend a little bit on H 545. This is a bill that's currently in Health and Welfare. They've asked us to take a look at a narrow section, primarily on page 7, regarding civil and administrative immunity. We have Allison Despathi here, who requested to testify, and if you could just introduce yourself and what which organization you're from, that would be great, and then I'm happy to hear your thoughts.
Okay, thank you so much, and thanks for finding the time. I know you guys have a packed schedule. I appreciate it. Allison Despathi. I am a co-director with Health Choice Vermont. We represent 5,000 Vermonters who really care a lot about ensuring that they can make private informed healthcare decisions here. So I was able to testify at Human Services in the House and Judiciary, and then also able to testify in Senate Health and Welfare. And so thank you for allowing me here, because I think really one of the concerns that a lot of people are seeing is very specific to your jurisdiction on this bill. So essentially, I just want to tell a little bit of a story quick. In the 1980s, early 1980s, there was a vaccine. It was diphtheria, pertussis, tetanus, and it was a live cell vaccine, pertussis, and it was causing a lot of neurological damage, seizures, and death. So pharmaceutical manufacturers of the vaccine were being sued and going out of business. One ended up being left. Their name was Lidural. They turned into Wyeth. They were bought by Pfizer. But because of that, what ended up happening is President Reagan in 1986 signed the National Childhood Vaccine Injury Act. And what that did is, instead of making manufacturers of vaccines produce a safer product, they said, we're going to give you a liability shield. So you are not responsible for the safety of your product. So they gave that to pharmaceutical manufacturers for vaccines that land on the federal schedule, and they also gave it to anyone giving a vaccine. And with that, in order to balance the scales of justice, really, is they said, if we're going to give this liability shield, then how are we going to provide compensation? We have to have some sort of legal recourse for people who might be injured or killed. So with that, in conjunction, they set up what was called the National Vaccine Injury Compensation Program. They also made it that providers originally had to give a 10-page informed consent benefit risk analysis to anyone who was getting a vaccine. So those were the two things that they did, because here they are coming in saying, we are going to offer this liability shield. So since 1988, when the compensation program was enacted, they have paid over $5 billion for vaccine injury and death. And how it relates to Vermont, and in my practice, I have a nutrition practice in the Northeast Kingdom in St. Johnsbury, and I work with over 200 people who've been vaccine injured. So I've worked with them through this process, and they come to me from a nutrition standpoint, because most of the time it's parents who are trying to say, my child's been injured, I want to do anything I can to try to help get my child covered and get them healthy because of what happened with the injury. And I know it's so tough when you start talking about vaccines, because they're immediately sort of polarized and politicized because of what's happened to science, and it's very unfortunate. And so one of the things I was wanting to ask is, if we were talking about any other product, so pretend we're not even talking about a vaccine, because I know that's like an instant trigger to people, and people sort of go into their camps on it, and what's happening on a federal level, it like causes a lot of chaos and is very triggering. But if we were talking about any other product that the state was going to potentially offer a liability shield for a provider, what would we be doing? Like, how would we make people aware? How would we say to them specifically that, you cannot sue this provider if you have a reaction to this product? So I just want to put it in that context of, would we create our own statewide compensation program the way they did on a federal level? Would we give them legal assistance? What would we do? So I think the reason that this comes up, and I know there's like a lot of history that plays into this. So the reason that this comes up is nobody has a problem with the Department of Health bill, in the sense of they want to procure vaccines, they want to make sure they're affordable, they want to make sure insurance companies cover it. They're doing their job, no problem. The part where people are struggling is that right now there's a federal vaccine schedule, and all of the vaccines on that schedule provide the liability shield to the pharmaceutical industry and to the administrators, which means if you have an injury or your child dies from that vaccine, you go to the compensation program. You don't go through the tort system. You can't sue the pharmaceutical companies, etc. For example, just to sort of put it in Vermont perspective, there was a girl, her name was Kaylin Matten. She was from Barton, Vermont, and she went to a wellness check when she was 7 years old, and she ended up with a Fluzone vaccine that contained mercury at the time, and she died. It says on the birth certificate, myocarditis, because of the vaccine. It took her family, her mom, Nicole, who has testified in the State House, 11 years to get compensation, and she got the highest amount of compensation from this injury program, which is actually heartbreaking to hear. I mean, it was $250,000 that her mom received for the death of her child from a vaccine. And so essentially where the concern is in this bill is if the federal government, the CDC, et cetera, pull a vaccine from the federal schedule, and this, for whatever reason it is, say hepatitis B, and this is me just putting in perspective hepatitis B, and I apologize, I know there's like a lot of history and information here. Hepatitis B was the first vaccine approved after pharmaceutical industries received this liability shield. It was the first genetically modified virus in a vaccine. There were 5 days of safety monitoring done. This is hideous, with 147 children under the age of 10. When you talk about a product that pharmaceutical companies are liable for the safety of, you're talking about 2 to 9 years of safety monitoring, and it's compared to a placebo. So because vaccines are not, the pharmaceutical manufacturers are not responsible for the safety of their product, no vaccine on the childhood schedule has been compared in a placebo clinical trial. And the reason this is relevant is because it gets to your guys' jurisdiction. So there's been no placebo controls on any vaccine in the childhood schedule, and they've been studied for 3 days, 5 days, or several months of safety monitoring, because the pharmaceutical industry is not responsible for the safety of those products. They know that if there's an injury or damage, that will go to the National Vaccine Compensation Injury Program, and they are not liable. So what we're saying here is hepatitis B, for example, there's been a petition filed. They did FOIA requests to the FDA. This is back in 2017 and 2018. They've done FOIA requests to get the safety monitoring data on hepatitis B as an example. And this is Recumbivax hepatitis B that I'm talking about. So the FOIA requests ended up resulting in a over 1,200, I think it was 1,264 page document that confirmed that hepatitis B was only studied for safety for 5 days after injection. Because of that, they have petitioned and they said you need to revoke or suspend the use of hepatitis B vaccine. So if, as an example, I'm saying, if they find that this did not go through adequate safety studying and that there are concerns around this, and if the federal government pulls the hepatitis B vaccine from the schedule, but the state decides to say, hey, we're going to stick with hepatitis B given to babies on the first day of life, or in the first 24 hours, then that is no longer, if the state chooses to do that different schedule, that is no longer going to qualify for the National Vaccine Injury Compensation Program. So what you're saying is, shouldn't, and I'm thinking of course, your constituents and patients, and I think of the people in my practice that I work with, shouldn't that person be made aware that this is no longer on the federal schedule, this is no longer going to be covered under the National Vaccine Injury Compensation Program, so shouldn't there be that information given to the patient? And I think one of the Department of Health people said, well, we don't want to cause any sort of distrust, we don't want to but there should be a question in the parent's mind. They should be able to seek questions and say, well, why is it off the federal schedule and why is it on the state schedule? And what does it mean if it's not covered in the National Vaccine Injury Compensation Program? I don't even know what that is. But if their child gets injured or died, they're going to want to know what that is. And so I just feel like from a state responsibility standpoint, and I'm thinking of patients in Vermont and your constituents, shouldn't there be a heads up if the state, even as simple as if the state was going to do a change that differed from the federal schedule. We're going to keep this vaccine, but now the federal government is saying we're not. Shouldn't the Department of Health at the very least report back to Senate Health and Welfare to say, hey, we've done this shift. We now have a difference in this. So that could be one possible path. And then the other possible paths, and Representative Burt did testify in Human Services with a possible amendment. He also testified in Senate Health and Welfare, I think it was yesterday or the day before, maybe it was Tuesday, and I think he'd be willing to come in. But just to try to say, how do we sort of balance this thing out if the state is now going to give the shield to anyone giving a vaccine? Should it be that there's informed consent that has to happen? And we know that informed consent is already in statute, but should there be more substantive informed consent that is given to the patient? Should the patient be made aware that there is a difference in schedules? Should the patient be made aware that this provider is no longer liable for what happens when this product is administered? It seems like there should be a level of transparency that happens with you guys implementing the shield, which is not common. I mean, correct me if I'm wrong, but I think there's maybe one other product that the state does this with, and it's a life or death situation in a drug situation. I could be wrong, but that's my understanding at this time. So if the state is going to offer the shield, how do you protect the patient? Like, how do you inform them? I think that's the fundamental question, which obviously lands on your guys' plate of how do you balance out this equation, really? So that's what we're concerned about. And the one thing I would say, and American Academy of Pediatrics had emailed the legislators in the House, and they had said, and this is something that they also verbalized in committee, was that providers give what's called a vaccine information statement sheet. And that basically says, you know, you might have a little fever, you might have a headache, and by the way, if you have an injury, contact the vaccine adverse event reporting system, and here's how you do it. The CDC for decades has said that is not informed consent. That's not offering someone informed consent. So a provider can't just say, here, boom, I've given you now informed consent. And so I think it's, those are some of the avenues that I just wanted to offer for where do you go? Do you go to the clinical office space with the provider and the patient and make sure there's honest transparency happening? Like, by the way, there's been a change in the schedules. I think you should be aware this is no longer covered on the compensation program. By the way, I cannot be held liable for anything that happens with this product. Or do you say, hey, Department of Health, I mean, obviously you guys know how it works, especially in this committee. You guys create law and policy and they execute it. So, you know, should the Department of Health come back to the Senate Health and Welfare and say, this is what we're proposing. This is why we are going with a different schedule, and here's our evidence, here's our reasoning, and, you know, what do you think about that? Should there be a level of oversight if that was to happen? And I'm kind of just scratching the surface on some of the history, but I needed you guys to try to have at least a little bit of that to see where this question comes up. And really, Human Services, when I testified there, I had like 40 minutes, and they were all very upset, understandably, how people have been, including myself, for like 40 years. Why do pharmaceutical companies have a liability shield on the product? That's the fundamental issue here, right? Like, that's really where, like, and there is legislation on a federal level where that could be changed, and states try to deal with that. States try to say, if you come do advertising for commercials in our state, then you're liable for the product. Like, so there are ways that people are trying to do that, but right now the pharmaceutical company is protected, and it basically lands on how do you make sure patients are also protected in their decision. So I think that's kind of the big thing. I did want to say Tuesday, when Representative Burt offered testimony, and I can get you a copy of this, or we could also have him come in potentially, is he did have some, besides the amendment he proposed in Human Services in the House, he did also have a little bit of a different approach for potential language in there, whether it's reporting back or it's you know, something that happens in the office between provider and patient if that provider is now going to have a shield on this product. So we can get that to you.
Yeah. Oh, we do have that language.
Okay, good. Okay, great. Okay, good.
Committee, any questions? Well, thank you.
Yeah, thank you for letting me take the time. I just wanted to make sure people knew sort of what was going on. And I know that vaccines, like I said, are very politicized and it's like a tough word to talk about, but I would just say if we go back to any product, if we were to do that, what would the action be we would take for the person getting the product? So I appreciate the time.
Yeah.
Okay, thank you.
So we're ahead of schedule, which is great. We also have the Department of Health here, and I feel like it's fair that we hear from the Department of Health as well for 15 minutes or so, however much time you need. Is 15 minutes all right?
Yes.
Okay, great. Yeah, so please feel free to join us and
thank you so much. I appreciate the opportunity. My name is Lauren Lehman. I'm the General Counsel at the Department of Health. And I really appreciate the opportunity to testify. You know, I'd like to take a step back about where the VICP, Allison just provided a very background on that. And it was created for access purposes. We as a country decided public health wise that, and public health recommends access to vaccines and to protect against communicable diseases of childhood and adulthood. And so in an interest, we need manufacturers to manufacture them, and the country needed providers to provide them. In the early days, there were significant tort lawsuits that were lengthy and costly. And so a lot of manufacturers and providers were saying, we're not going to provide this access. So to insulate the providers and the manufacturers, the federal government capped capped damages you could receive in a civil court to $1,000. If you wanted anything above $1,000, you needed to petition the federal government into this vaccine injury compensation program. Still a lengthy process, but there's a separate court within the federal claims court and a separate panel, and they review those claims. There's a vaccine injury table, etc., to move through the causation process faster. But as you heard from Allison, it can still take 11 years. It can still take, on average, 1 to 3 years to go through that process. Vaccines are added to that for coverage in the vaccine injury compensation program by the CDC recommending it, but also by Congress adopting a excise tax to pay into this fund. And then from the fund, people are reimbursed. So it removes vaccine liability from the tort system and caps what individuals can get for compensation for injury.
I just have a question about that. If a vaccine is taken off the schedule, and somebody sustains an injury as a result of that vaccine, and it's not on the schedule, is that tort shield removed from the pharmaceutical company?
Yes. So if it's not on the schedule, and there are some, because what's covered by VICP, or VICP is what they call it, vaccine injury compensation program. If it's not covered by that, which dengue fever, for example, isn't covered by that, then you can go through the tort system to seek compensation. And it would be similarly challenging to go through a legal system, but your damages could be much higher, and it wouldn't be taxpayer based.
So if I am understanding, concluded, if Vermont moves forward with saying this is the Vermont schedule and some of those things are no longer on the federal schedule, someone may not be eligible to go through the victim injury compensation program, but they can now sue the pharmaceutical company.
Yes.
Okay.
And I want to point out that the provision in H545 you're seeing at is very narrow, right? It is healthcare providers, for healthcare providers, for injuries to somebody caused by a vaccine administered in accordance with the commissioner's recommendations. So the commissioner's recommendations under this bill will be made in consultation with a committee that's composed of experts in the field, doctors, researchers, etc. If a provider is giving a product that, based on those scientifically sound, evidence-based recommendations, and the person is injured from that product that's administered in the correct way, at the correct age, and the correct dosage, this is saying that that healthcare provider shouldn't be liable for using that product. we can't provide, and we don't provide, and it does not provide a liability shield for the pharmaceutical manufacturer. And if it also doesn't provide a shield, should the healthcare provider be grossly negligent, be reckless, go off the schedule, ignore allergy signs, etc. So it's a narrow liability provision, and it's intended again to protect access. We want people to be able to access at pharmacies, at their doctor's office, the vaccines that are scientifically sound, evidence-based, intended to protect. And 95% of Vermonters are accessing these vaccines, want access to these vaccines. And I will also say, vaccine injury is incredibly rare. 1 in a million results in compensation. Of 1 in a million vaccines distributed, that results in compensation from the Vaccine Injury Compensation Program. So over the life of its, out of 80 billion doses of vaccines distributed over the last 10 years, 1 in a million has resulted in vaccine injury compensation. So it's so rare. There's still an avenue, recourse for the patient. We're trying to protect access by allowing providers that narrow liability shield, which is consistent with the naloxone one, as well as the gender-affirming care and reproductive health care liability protection. There's also, I had one more thought, but it's narrow scope. Oh, informed consent. So 12 VSA 1909 already requires informed consent, right? For all foreseeable risks, a healthcare provider is liable under medical malpractice law for not disclosing the foreseeable risks of a medication. They aren't in other spaces required to disclose your liability avenues. If you get a prescription for antibiotics for strep, nobody is saying to you, if you have anaphylaxis, here's the name of a med mal lawyer that you can pursue, a medical malpractice attorney to use for suing. So to have to disclose your liability options when it comes to a vaccine administration, I think it's unnecessarily alarming. It makes it sound like there's more risk than there is. And it's outside kind of the scope of the practice of the physician with the patient.
Senator,
You may know the answer to this. When the vaccine schedule that we currently use was developed, did that rely solely on US research, or did that look at sort of global research?
I'm not sure. I'll have to look into that. My guess is it is global, because when you marshal, from my very narrow knowledge of the drug application approval process at the FDA level, you're going to marshal all your resources to get that drug approved, whether the study was done in the US or outside the US.
That was sort of my guess as well, but I'd love to know, and certainly I think, that broad brush, because I know everything Europe specifically doesn't provide liability shields and does have in fact, in many instances, much lengthier approval process. So if we're looking at those studies too, I think we're getting a really broad look at safety and efficacy. So thank you.
We'll also be looking at recommendations from national organizations, so not just on the state level and but we're looking at the American Academy of Pediatrics, American Academy of Family Practitioners, etc. So there's going to be a wide breadth of knowledge brought to bear. And there'll be transparency, as there used to be, about what we're relying on and what that process for the recommended schedule will be. Hopefully it'll align with the federal government. Right now, nothing's changed with the injury compensation program, but things have changed with the schedule and things are not going according to the process that was previously used. We haven't seen studies, we haven't seen science, and so this was really trying to emulate that system at the state level, and to kind of insulate us from the things that we don't understand or don't have that transparency to it.
That makes a lot of sense. Awesome. Thank you.
thank you. Anybody else have questions?
Just a quick one, yes, thank you. So, I don't have the bill right here in front of me. So who is protected in this bill? Is it just those who administer the immunization shots? It doesn't include like the Commissioner of Health or Anybody else, just those individuals who administer the immunizations?
Yes, so the Commissioner of Health is somewhat protected under state sovereignty. I believe Katie McLean spoke to it the other day about what the standards are. I'm not an expert in that space. There's some state sovereignty protections that you have to show that his recommendation was reckless, without due diligence, etc. So the department is protected by that, but this liability protection would just be healthcare providers who administer it in accordance with that state recommendation.
Intentional, I believe, intentional misconduct is also the other prong of getting through sovereign immunity.
Yeah.
Just to answer your question there. Okay, so thank you for your testimony and for being here.
Thank you for the time.
Yeah. So again, our jurisdiction on this is essentially page 7, lines 1 through 7. I know a lot of conversation about informed consent and also reporting back to the Health and Welfare Committee. Those aren't really questions for us, but rather it is if a healthcare professional who prescribes, dispenses, or administers an immunization can be immune unless they are grossly negligent, reckless, or engage in intentional misconduct. Based on everything I've heard, I don't have any proposed changes to the section that we have jurisdiction on. Committee, do you have any comments or suggestions that you'd like to see? Or are you fine with the language as it's written?
I'm fine.
The language is fine as written. When we have more time in a future space, I might be interested in looking at some of the advertising. Like, it is a little shocking to me that pharmaceutical companies have this liability. And if there's something to be done to address that at the state level, I'd love to look into that, but not for the purposes of this bill.
So I'll let Senator Lyons know. I think they're doing markup on Friday and probably, well, I don't know when they're rolling it out, but either way. That wraps that up.
Well, I might just say that the area that we're doing a drive-by is lines 1 through 7. I don't have any problem with that. I need to see the whole bill, take time to read the whole bill and hear it, and we'll also put it as to how I vote or against, but the section I'm fine with that.
Okay, great. Okay, so we've got 10 minutes until we get back to 193. We'll have kind of